Good afternoon. My name is Erica Gaddis. I'm a Water Resources Director at SWCA Environmental Consultants, and it's my pleasure to welcome you to our webinar today. We want to give you an update on the 2023 Revised Waters of the United States definition. This webinar is targeted primarily for the regulated community, and we're aiming to provide an update on these ongoing efforts of the US EPA and the Army Corps of Engineers to define waters of the United States for purposes of Clean Water Act jurisdiction. We've been through a number of rulemakings together over the years. Today, we're going to focus on the most recent rulemaking, which was published in the Federal Register on January 18th, 2023. Today, you'll have the opportunity to hear from some of SWCA's top wetland practitioners from around the country about how the latest rulemaking will translate to changes on the ground. We've also teamed up with Holland and Hart to bring you a legal perspective on this rulemaking and related legal matters, including the SWCA versus EPA case that's currently pending before the Supreme Court. Before we get started, I want to go through just a couple housekeeping items with respect to technology. So this webinar is being recorded, and that'll include any questions that you put into the question and answer box. Be aware of that. Because we have such a large audience today, it looks like we're currently sitting at 333. We have microphones muted, and we have also turned off the chat feature just so that we can manage the questions in one space. So if you have a question, please feel free to put it into the Q&A question and answer feature at the bottom of your screen on Zoom. We have left time at the end of our webinar today to answer your questions live, and we would be happy to answer those questions we don't get to following the webinar. And we'll make sure you have our email addresses so that you can send those questions on if we weren't able to answer them live. So with that, I'd like to turn the time over to Daniel DeGiudi, and we'll get kicked off here to introduce our panel.
Thank you, Erica, and welcome everybody attending the webinar. I was going to say good morning or good afternoon. I'm not sure which, depending on where you are. I think we have 4 time zones represented among the panel, and probably just as many among the participants attending, which is symbolic that this is an important topic because this is a national rule that affects wetlands and jurisdiction of water bodies all the way across the country. So you just heard from Erica Gaddis, and she is SWCA's Water Resources Director. I'm Daniel DeGiudi. As Erica mentioned, I am a senior biologist and project manager in Minneapolis. Joining us today is Ashley Peck, and Ashley is an environmental attorney and a partner at Holland and Hart, and she is located in Utah. Our panelists from SWCA includes Bonnie Rogers, and she's a professional wetland scientist and a regulatory specialist based in California. Adam Hoyles, a professional wetland scientist and regulatory specialist based in Florida. Heath Garner, a senior wetland scientist and regulatory specialist based in Arkansas. And Marcus Hope is a professional wetland scientist based in Texas. And Marcus is going to be monitoring the question and answer chat window. So he will be feeding me some questions at the end. So if you have any questions that come up during the course of the webinar, just type them in the chat and Marcus will relay them to me at the end, and we will pick as many as we have time to address at the end. The highlights of things we're going to talk about today: we're going to talk about the rule for defining waters of the U.S., which was published in the Federal Register in January, and it will take effect March 20th. And this, as Erica mentioned, redefines waters of the U.S. with implications all across the country, and implications for wetlands and how wetlands and water bodies are regulated under the Clean Water Act. We'll describe a new classification scheme defined by the new rule, and that you're going to find it's very similar in some ways to a previous scheme, but it's changes a little bit. So we'll highlight what's different in the new classification scheme, and we're going to talk about some areas where case-by-case analysis will be required to determine if wetlands are jurisdictional, and 2 new standards that are being rolled out are the relatively permanent standard and the significant nexus standard. So again, there's some similarity to past rules, but there's some new nuance and some new ways to approach this. And then we will conclude staying with some topics that are looking at what's coming up in related regulations, court decisions, and agency guidance. First, I would like to call on Adam Hoyles, and he is going to provide a background and history of the waters of the United States. And he's going to help us understand, why do we keep having webinars on waters of the United States, and why do we keep having new rules redefining waters of the United States? So Adam, please take it away.
Thank you, Daniel. I've been working as a consultant for about 28 years, working for private developer, energy infrastructure, and government clients. My background is in wildlife ecology from the University of Florida. So I often find myself responding to the question, why does policy on regulated wetlands change so often? To answer this, I'll take us back to first principles. Waters of the United States is a threshold term in the Clean Water Act, and it establishes the geographic scope of federal jurisdiction under the Act. Clean Water Act programs include establishing water quality standards, TMDLs, NPDES permits, and our primary topic today, which is Section 404, which establishes a program to regulate the discharge of dredged or fill material into waters of the United States, including wetlands. Clean Water Act does not define waters of the United States, but rather it provides authority for the EPA and the Corps to define waters of the United States in regulations. Since the 1970s, the EPA and the Department of the Army have defined waters of the United States by regulation. With the basis of definition and rulemaking, instead of by congressional mandate, the rules are open to be challenged and modified or interpreted by the courts. This has led to a continuous shaping of policy and rulemaking based on the various court interpretations of WOTUS. Part of the problem is the difficulty in interpreting the powers of the federal government as it relates to the Constitution. Primarily, the basis is from the Commerce Clause, which grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And the concept of commerce is going to be a term you're going to hear throughout the regulations. With the basis of regulation formed by rules and policy, which are frequently challenged, I would expect the pattern of periodic legal challenge shaping policy to continue. In 2001, the Solid Waste Agency of Northern Cook County versus Corps case is known in the industry as the SWCA decision. The Corps had used a tenuous interstate commerce connection as justification for what was called at the time the migratory bird rule. In practice, it granted the Corps very broad power to regulate any isolated wetland, no matter how far it was located from a traditionally navigable water. This case successfully challenged that rule. In SWCA, a 5-4 court held that the use of non-navigable, isolated, intrastate waters by migratory birds was not by itself a sufficient basis for the exercise of federal authority under the Clean Water Act. In 2006, Rapanos versus US and Carabel versus US. In this case, the court affirmed the relatively permanent, standing, or continuously flowing waters as being jurisdictional, and Justice Kennedy concluded that to constitute navigable waters under the Act, a water or wetland must possess a significant nexus to waters that are or were navigable in fact, or that could be reasonably so made. He stated that adjacent wetlands possess the requisite significant nexus if the wetlands, either alone or in combination with similarly situated lands in the region, significantly affect the chemical, physical, and biological integrity of other covered waters, which are more readily understood as navigable. And you will see references to similarly situated later. The application of these concepts has been subject of a vigorous debate between consultants, the EPA, and the Corps, which then led us to the 2015 Clean Water Rule, which expanded the definition of WOTUS and offered fewer case-by-case determinations, but it also included some broadly defined wetlands. Texas coastal prairie wetlands, Carolina bays, Delmarva bays, western vernal pools in California, Pocosins, and prairie potholes became WOTUS. Some states saw this as an overreach of federal regulation, and the rule immediately triggered legal challenges. In February 2017, President Trump issued Executive Order 13778, directing the Corps and EPA to review and rescind or revise the rule, to consider interpreting the term navigable waters in a manner consistent with Justice Scalia's opinion in Rapanos. And Justice Scalia had ultimately concluded that WOTUS should only include relatively permanent, standing, or continuously flowing bodies of water, because according to him, that was the definition of waters in the Webster's Dictionary. And this view posed a much narrower test for determining WOTUS. That then led to the repeal in 2019 which basically reinstated the 1980s regulations and implemented them consistent with the Supreme Court cases, including Rapanos, with applicable guidance. It offered a more definitive definition of WOTUS, but in the most general terms, it reduced areas defined as WOTUS. So in 2020, the EPA replaced the 2019 rule with the Navigable Waters Protection Rule. And in 2020, it was immediately challenged in the Pascua-Yaqui tribe versus EPA. In that case, the U.S. District Court for the District of Arizona vacated the 2020 Navigable Waters Protection Rule. And this effectively reinstated the definition in effect prior to 2015 in 28 states. In light of this order, the agencies halted implementation of the Navigable Waters Protection Rule. So in 2023, WOTUS is again being redefined. I'll leave the details of these changes to Bonnie and Heath. And keep in mind that the final rule was published ahead of the Supreme Court's decision in Sackett versus EPA, and Ashley will cover this later in the presentation at more length. Thank you, and back to you, Daniel.
Thank you, Adam. Now I'll call on Bonnie Rogers to talk to us about what is in the new rule. Adam gave us the background of how we got to the point where we need a new rule. Now Bonnie is going to summarize what is in the new rule. Bonnie.
Thanks, Daniel. Yep, it's been a long history to get where we are today. I'm Bonnie Rogers. I'm a senior professional wetland scientist at SWCA out of our Pasadena office here in Southern California. And I'm going to dig into the new rule a little bit here in the details, just so we can look at some of the changes and things ahead. So I'll start with the recategorizing of waters in the rule. So the first water type here that we look at when assessing whether we have a jurisdictional water or not is called A1 water. So these are our navigable waters, territorial seas, and interstate waters. And we're very familiar with these. These are our oceans, rivers, and in the prior rules, these were just separated out in the regulation. So now they've been combined into the A1 category, makes things a little bit simpler. It doesn't change how we view these types of waters, but we can refer to them collectively now. The second waters type are our A2 waters. So these are impoundments, and an impoundment might be a dam. In the past, the regulations used the citation at A2 for tributaries. So just a little reshuffling there of where the water sits in the regulation citation. So under the new rule, impoundments are waters of the U.S. If they were constructed out of waters of the U.S. So they are by definition if those waters were previously waters of the U.S. And so you might need to look at some historic aerials, some other data available to determine if your impoundment was a water of the U.S. when it was constructed. Our third water type are A3 tributaries under the new rule. So these are tributaries that lead to our A1 waters. So I like to call the A1 waters our navigable or base waters, our oceans and rivers. And so we're looking to see which of the tributaries to those A1 waters, if they're jurisdictional. So if you have a tributary to an A1 water, it's jurisdictional under this category. Or if it's not a direct connection to an A1 water, it can also be an A3 tributary if it meets one of the new tests. So these are two tests that Daniel introduced earlier, the relatively permanent standard and significant nexus standard. So you might need to apply one of those to determine if you have an A3 water. And we'll get into that in the next slide. Our A4 waters, these are wetlands. So our the definition of adjacent wetlands under the new rule is the same as it's been historically since the 86 regulations. So that's not changing. That's not a change. But you can apply one of those two tests as well if you don't meet that first wetland adjacency situation. So A4 waters are wetlands. And lastly is kind of what you might think of as the catch-all. These are what folks refer to as other waters in the A5 category. So these are not wetlands that are adjacent, but they're non-adjacent wetlands. Or they could meet one of the two tests. And then the second item to note here is that the commerce test is no longer effective. So in prior rules, we might use commerce as a way to assess the water, and that's no longer the case. Okay, so our two tests, we are fairly familiar with these standards already because we know the terminology relatively permanent. We also know the terminology significant nexus, but they've created these two new terminologies for these tests. The first one, it identifies continuously flowing water. So think of your river that flows year round or seasonally as a result of snowpack. A relatively permanent water could also be one that has a continuous surface connection. And I would point out here, this does not mean a continuous water flowing surface connection. And we'll look at that in the next slide. Under the significant nexus standard, we're looking at whether there's an effect on downstream water. So not that continuous surface connection, but whether we have a biological, chemical, or physical connection and a significant effect on our downstream or A1 waters. So relatively permanent standard. This is the text from the rule. It's a test to identify relatively permanent standing or continuous waters connected to your A1 waters and waters with a continuous surface connection. So what does that mean? In the lower left here, that means a feature that is abutting or touching. So that one's fairly clear. The second is if it's connected by a discrete physical feature, like a swale or a pipe or a culvert. So we're looking at whether there's some sort of hydrologic connection between your subject feature and your relatively permanent water. And this is a notable change in the new rule. We haven't seen this before in this way. And then lastly, it also includes connection by a natural landform like a riverbank or a berm. So these here on the left, if you have one of these three situations that are included, that does not sever your jurisdiction to an A1 water. Okay, so what's it mean if you don't have that continuous surface connection? What's an example? That would be sheet flow or flooding. It's not a discrete feature. Or shallow subsurface connection. That's something you would look at under the significant nexus evaluation. And then lastly, separated by a human-made barrier. So for example, an elevated railroad track on a berm that severs hydrology. All right, our second test, significant nexus standard. So this is when you don't have a continuous surface connection, or you're not adjacent to a relatively permanent water. So you've looked at your relatively permanent standard, that doesn't apply, you're gonna move on to your significant nexus standard. And so in the new rule, this is a notable change. We have these 5 new factors over on the right: distance, hydrology, size, density, landscape position, and climate variables. So in previous regulation, these weren't defined. These were provided mostly by guidance and policy. So now we have these 5 categories that we'll use whenever we have to apply this standard. All right, another notable change. In prior regulations, we had the terminology called relevant reach. And if you look on the upper right there, you'll see the white circle if that's your project or subject area. In the past, we would analyze the immediate subject reaches by stream order branch that were coming into that site. Now, under the new rule, they've changed this terminology to the region, and it refers to the entire catchment. So you will look at all of the feeding tributaries of that watershed that lead to your project site. So that's a notable change, because in the case where you might need to apply the standard, you'll have to expand your assessment somewhat to include these other incoming feeder tributaries. And this is a figure that I have a key down here on the lower right, but it's basically just an example of how many different case-by-case scenarios you could have under the rule. So we haven't moved away from that. With these 2 new standards, they provide some clarity, but we're still looking to apply them on a case-by-case basis. And the other thing I wanted to note is that under the new rule, the agencies expect there to be a slight increase in the significant nexus evaluations that are provided, but they don't expect those to result in an increase in positive jurisdiction. So they might have to do a little more homework at our site, but it doesn't necessarily mean it increases the number of waters that are being regulated. All right, and this is a slightly different topic, but a heads up on things around the corner. So the Corps in December 2022, just the end of last year, released the draft interim National Ordinary High Watermark Manual. And this is brand new. So we've seen an Ordinary High Watermark Manual and data sheet here in the Southwest since 2008. But not all the regions across the country have had an ordinary high watermark data sheet. So this is slightly new, and the manual compiles decades of information, data, and research from the Corps' research center in order to come up with this weight of evidence approach. So you're looking at the strength of the evidence and context of what you have, and the strength of each of your indicators that you're seeing on site to come to a conclusion about your delineation. So this new data sheet here on the bottom, there might be a learning curve for everyone to get familiar with this data sheet, and we think the final might be released early next year. So heads up on that one. And I think that's it. Back to you, Daniel.
Thanks, Bonnie. Now I'd like to introduce Heath Garner, a wetland specialist in Jonesboro, Arkansas. And Heath is going to complement what Bonnie told us. Bonnie told us what is a water of the U.S., and Heath is going to tell us what is not a water of the U.S. Heath.
Thanks, Daniel. Ken helped me notice a few questions already coming through, and a lot of this will pertain to those questions, so we'll get them answered. So yeah, I will discuss the exemptions as well as the updated United States Department of Agriculture memorandum that's been put out. Again, I'm an ecologist and a wetland specialist in Jonesboro, Arkansas. So I've done a lot of work in the central Mississippi alluvial valley and worked with core districts between the Appalachians and the Rockies. So pretty widespread geography. And although I'm in Jonesboro, I do work out of our Arlington, Texas office. So some of the list of exclusions that has been released as part of this new rule, it should be noted that these exclusions are now codified in the new rule, which hasn't been done previously in the other rules. So these are pretty much set in stone. Some of the exclusions are the same as the previous rules, and some of them are new or modified from the previous rules. Some of those that have been consistent from the past rule making to the current is waste treatment systems and certain canals or certain ditches. Waste treatment systems are excluded if they are maintained as they're designed. So, as long as they are functioning as they were designed and constructed, they are excluded. Certain ditches are excluded, but they're specified in the new rule that these are excavated wholly in and draining only dry land, and they don't carry relatively permanent water. So if it's obviously a roadside ditch is an example of something that would be automatically exempted, that's designed solely for draining water from upland situations. Another example where it wouldn't be is, say there's a channelized stream or a canal that may have a ditch-like appearance, but because these have relatively permanent water, they're most likely still going to be jurisdictional. Other exemptions include artificially irrigated areas, and these are areas that would revert to dry land if irrigation ceased, as well as artificial lakes or ponds that are excavated and not necessarily impounded or diked to dry land. So these are upland situations that are excavated to retain water. Those will be exempted or excluded. So continued exemptions are water field depressions, and these are specified in the rule as borrow pits or maybe even construction equipment ruts, or things that would potentially isolated natural depressions in upland situations. And these things would stay non-jurisdictional or excluded until they later reverted to any new definition of waters of the United States. Swales and erosional features are also excluded under the new rule, and these basically include upland swales that or erosional features like gullies and small washes and uplands. On this slide, you can see an example of an eroded swale and an upland drainage that would be exempted under the new rule. And finally, prior converted cropland is included as an exclusion. So prior converted cropland was a concept that was defined as part of the swamp buster provisions of the Food Security Act of 1985 that we commonly refer to as the Farm Bill. This terminology and determination was derived for protecting wetland conditions on the agricultural landscape and maintaining farm subsidies to farmland owners, farmers, and producers so they can continue to manipulate those fields or maybe in associated drainages without violating the Farm Bill and Section 404 of the Clean Water Act. To elaborate further on that, prior converted cropland is still exempt as long as it's considered cropland. And so this change of use definition is clarified within the new memorandum between the U.S. Department of Agriculture and the United States Army Corps of Engineers and the EPA. Its exemption is honored as long as the field is still available for commodity crop production. So that's the main key. And there's a specific list of things in this memorandum that are not considered eligible to meet the standard of ability for commodity crop production. So those would include residential or commercial developments, energy infrastructure, and so forth. So otherwise, prior converted status is only available to farmers and farmland owners who maintain farming practices. It's not required or needed as part of a jurisdictional determination of any particular field, as the U.S. Army Corps of Engineers considered it at the time of conversion, or considers it as is at the time of conversion. So if you're going to have a change in use on a particular field other than continuing crop production or commodity production, then the Corps of Engineers is going to look at it as how is it today? And then they're going to look at it under the two tests that were previously discussed by Bonnie and Adam with regards to whether it's a relatively permanent water or does it have a significant nexus to another jurisdictional feature that would provide it with natural hydrology and it would convert to a wetland on its own if agriculture or artificial irrigation cease. So this is an example of two prior converted cropland fields, just to kind of give you an idea of where this is going on, where the line is drawn. Both of these are on the same farm or project area. The one on the left is solely provided by artificial irrigation and would revert to uplands if irrigation ceased. The one on the right is on a lower elevation and connected to the floodplain of another relatively permanent water or a river. And you can see on the image to the right, there's an outline showing how that surface water is connected from a relatively permanent water and could spill over and does spill over into this prior converted cropland that would provide natural hydrology. And thus, if it were delineated as a wetland at the time it was converted, it would probably be jurisdictional by the Corps of Engineers. So I think that's back to you, Daniel.
Okay, thank you, Heath. Well, no discussion of waters of the U.S. would be complete without a discussion of litigation and the Supreme Court. So I'd like to welcome Ashley Peck, a partner at Holland and Hart, to talk to us about prospects of how waters of the U.S. may be affected by action in the federal courts.
Great. Thank you, Daniel. Appreciate that. Now that we have a great overview from Bonnie on the two tests and overview on the exemptions from Heath, I'm going to now tell you how the Supreme Court could step in and turn it all upside down in the Sackett case. As Daniel said, I'm an environmental attorney. I'm based in Salt Lake City, but I do work throughout the Mountain West and elsewhere, helping clients get permits for large projects, defend enforcement actions, and do litigation regarding the Clean Water Act, notwithstanding all the uncertainty we've all faced over the last decade or so. So if the name SACIT sounds familiar to you, it's because these folks have been up and down in the courts since 2007. This litigation about the wetlands on their property has been ongoing since then. In 2004, the SACITs purchased a residential property in Idaho, and they went ahead and began developing the property by removing material and placing sand and gravel and fill on a lot. And then they received an order from EPA telling them to stop, to remove the fill and restore the property. The SACITs appealed that decision. The case actually wound its way through the federal courts for several years on procedural issues, even went up to the Supreme Court. Finally, in 2021, we have a substantive decision on their property from the Ninth Circuit. And the Ninth Circuit held in favor of the EPA's original conclusion that the wetlands at issue are adjacent to a jurisdictional tributary and have a significant nexus to Priest Lake and are therefore considered waters of the United States. So the SACITs then appealed, just back up a little bit, the Ninth Circuit, going back to Bonnie's discussion of the tests and Adam's discussion of the history, the Ninth Circuit applied Justice Kennedy's significant nexus test from Rapinos in its decision, and it specifically rejected the SACIT's claim that Justice Scalia's continuous surface water connection or relatively permanent test that Bonnie talked about should apply and is the governing legal standard under the court decision. Just to back up on that, those two tests came out of Rapinos, but because Justice Kennedy was the deciding vote, his test of the significant nexus test under Supreme Court case law has been applied as the controlling standard in those cases. But the SACITs went ahead and appealed the Ninth Circuit's decision to the Supreme Court. The court granted certiorari at the beginning of last year. We've had briefing back and forth on that, and ultimately arguments were held in October of 2022. The SACITs have broadly asked the court to really revisit the Rapinos test and adopt the Scalia test as the controlling rule. So throw out the significant nexus test as invalid. Their characterization of the Scalia test is actually even a little bit narrower than how the Trump administration applied it in their version of the WOTUS rule. But I think what's important to keep in mind here is what the Supreme Court said it would review. And they limited their review to the following question, which is whether the Ninth Circuit set forth a proper test for determining whether wetlands are waters of the United States under the Clean Water Act. So I think the big question will be how the court goes about addressing this and how broadly its decision will ultimately be. As I said, oral argument took place in October of 2022. The justices expressed a lot of skepticism for both parties' tests. In fact, Kavanaugh questioned the SACITs by saying and noting that their test had been rejected by 7 prior administrations and made it pretty clear that there was skepticism that should be the controlling standard. But several of the justices also expressed concern about the nebulous nature of the significant nexus test and really the lack of predictability for the regulated community. I think it's notable that shortly after the Biden administration finalized this rule, they actually sent a letter, the lawyers on the case sent a letter to the court arguing that the final rule actually addressed some of the uncertainty that the justices raised during oral argument, and then made an argument that the final rule actually supported their position in the case. So I just wanted to note, because it's interesting, this is a very bad picture, overhead picture of the Ninth Circuit of the SACIT site. As I said, it's a residential property about 300 feet from Priest Lake. It's interesting because the EPA actually found 2 bases for jurisdiction. They said that there's actually it was adjacent to a tributary, which was Kalispell Creek, and also that the wetlands on the property had a significant nexus test for Priest Lake. So even if the Supreme Court were to throw out the significant nexus test, it's very likely that the SACIT's property would still be jurisdictional under the adjacency test, which is just interesting to people like us. Like ultimately, at the end of the day, this creates more uncertainty. So So hard to say what will happen. We're expecting a decision from the court, hopefully around June, but the extent to which they affect the significant nexus test has big implications, of course, because as Bonnie noted, the Biden administration has adopted both tests in its final rule. And so how that plays out and whether the court's decision expands beyond wetlands will be what we're all watching for to find out how much change we can expect to see in the future. One more note on the legal side, no one will be surprised, but the final rule has already been appealed in the U.S. District Court for the Southern District of Texas by a coalition of 17 different industry groups, and the state of Texas will likely see other states join. There's been a lot of political wrangling by states arguing to the administration that they should not have adopted this rule in advance of the SWCA test. Part of me thinks that the way they finalize this rule is part of their litigation strategy, but we will see how it all plays out. Lots to watch coming from the courts. Thanks, Daniel.
Thank you, Ashley. Now I'd like to welcome back Erica Gaddis, Water Resources Director with SWCA, to give us an overview of some things to watch for.
Great, thanks so much, Daniel. So just a couple of things to wrap up today that we want to put on your radar that we are tracking and will be tracking over the next several months. You just heard from Ashley about the legal aspects, so we'll be keeping an eye on what happens with SWCA, as well as with the litigation that's associated with this current, most recent rulemaking, and especially how that plays out across the country in terms of which rules are in effect at any given time. So we'll keep an eye on that. There's also a number of guidance elements that we think are coming that will be important in helping to implement and interpret some aspects of the rule. So our understanding is that the next step for the agencies will be development of a memorandum of understanding between the implementing agencies of the Corps and EPA, just to ensure that as a federal family, they are interpreting things consistently. We also understand that they will be issuing implementation guidance for the rulemaking itself in the coming months, and it'll be interesting to see if that's national implementation guidance or if that's regional. So we'll be watching for that as well, and of course integrating all of that guidance into our practice. And then finally, you heard from Bonnie about the ordinary high water mark manual. We're looking for finalization on that updated guidance that was released in December of last year. Don't know yet if there will be additional changes in that final guidance. We're also keeping an eye on several other related regulatory actions that could occur at the federal level. Ongoing is the 401 rulemaking. For those that don't keep track of all of these things, 401 is the section of the Clean Water Act that provides states and some tribes the ability to certify any federal actions with respect to water quality implications within their jurisdiction. So this is a rulemaking that went out for comment last summer. Comments closed on August 8th, and we're waiting to see that final rule. This really speaks more to the kind of scope that states can use in issuing 401 water quality certification decisions, the amount of time that they can spend in their review. And all of that has been up for a lot of debate over the last several years. And then finally, we hear rumor, and it's really just rumor, that the Corps may be considering changes or perhaps even eliminating an element of their current permitting regulations called Appendix C, which relates to the procedures that are required for the protection of historic properties under the National Historic Preservation Act. And that could affect the scope of the Corps' analysis associated with its federal actions, including permitting, such as 404 permitting, which is largely the subject of today's webinar with respect to the new rulemaking. And then finally, we're also keeping an eye on what's going on within our states. We have seen rulemakings across several states in the last couple of years related to wetlands and how states want to choose to protect their own waters of the state. And those definitions sometimes align with waters of the United States and sometimes can be very different. So we'll keep an eye on that and make sure that we understand both the federal and state regulations as we move forward. And then we're also aware that there are several state efforts to assume primacy of the 404 program, which means states would implement the permitting program that's currently managed by the U.S. Army Corps of Engineers themselves. So there are a couple of states that are working to assume that delegated authority, and we'll keep an eye on that as well, as it could change process and applications, etc. So with that, that's all I have in terms of things to watch for. It's going to be a busy year in 2023 when it comes to the Clean Water Act and waters of the US, and we'll keep an eye on things and keep you up to date. Back to you, Daniel, to wrap us up.
Thank you, Erica. We're going to open up to some questions and panel discussion. And at the end, we'll show a slide with the contact information or emails for all the panelists if you want to reach out to us. The recording of this webinar will be available later on the SWCA website and the SWCA YouTube channel. And we can also make the slides available to anybody that wants to reach out to us. We have a few questions to start the panel discussion. So I'll start with 3 of these questions, and then we will look at the questions that you've submitted through the Q&A. So just a reminder that if you have anything else you want to ask about, put it in the Q&A and chat, and we will get to as many of those as we can by the top of the hour. First question, will the new Clean Water Act definitions for waters of the US and the standards tests, will they result in longer permit request timelines? Who wants to take that question on the panel? Is it going to take longer to get permits?
As far as we know, it should be similar timelines, because right now there's a lot of case-by-case determinations, and we expect that to be reasonably similar.
Okay, thank you. Anybody else want to add to that?
Add that without the implementing guidance that we're expecting from the agencies, we're not sure exactly if that would affect timelines.
Okay.
So definitely maybe.
Definitely maybe. So there's going to be a little bit of a learning curve for the Corps and for consultants as the guidance is rolled out. But presumably once we all become familiar with the guidance, we may not see delays in permitting. For projects that have received a recent approved jurisdictional determination, is there a risk that the Corps of Engineers could reopen those determinations? Could somebody explain what a AJD, an approved jurisdictional determination, is, and then answer the question, is there a chance those will be reopened?
Yeah, I'm going to tackle this one. This is a common question. Historically, approved JDs, which are when the Corps makes a final agency action decision on what is and is not jurisdictional for the assessment area. Historically, those AJDs, they're essentially good for 5 years, unless conditions have changed. And so, you know, when we had the Navigable Waters Protection Rule, which is now vacated, a lot of those AJDs excluded ephemeral waters because that was part of the regulation. And so now the agencies, when they look back at those AJDs that were issued under the Navigable Waters Protection Rule, they might not be able to rely on them because they don't have the delineation that's necessary under the current rule. So the new rule does not invalidate any AJDs automatically, but you definitely want to check with us if you have an AJD before moving forward in the permitting process or anything like that. Because there is a chance that if it was issued under the Navigable Waters Protection Rule, you'd have to reopen the AJD. Now, we're currently under Rapano's guidance, not the vacated rule. So if you received an HAD, say, last week, then it might be good for the next 5 years, depending on how those resources were assessed at this particular site. And you can look to the Corps' regulatory guidance letter 0502 and 1601 and their 2022 memo.
Okay, thanks, Bonnie. Next question. How is legal uncertainty affecting how we advise clients? And I'll direct this one to Ashley because it asks for a legal uncertainty.
Sure. I think for the most part, it requires a conservative approach. I think I mostly get involved when projects are, large, have some potential controversy because of their size or something else. And we want to find the quickest and most efficient way to construction. So being in the middle of a flip-flopping rule is the last place that we want to be. So I think on a lot of projects, we've elected and advised clients working with consultants like SWCA or others to develop a permitting approach that is flip-flop proof on this rule. So where we might have had an argument under the Navigable Waters Protection Rule, didn't make it on projects as to jurisdiction, conceded jurisdiction, and went ahead and permitted, because you don't want to have the uncertainty that Bonnie just mentioned informing your permit decision. So I think a lot of us on this webinar have probably advised clients similarly to continue to take a conservative approach and expect uncertainty and expect change. And a lot of times that means figure out a permitting approach that just concedes jurisdiction, unless there's a really good reason not to.
Okay, thank you. I'd like to turn the question to the wetland scientists on the panel. From the standpoint of a wetland scientist, how do you advise clients in regard to potential uncertainty?
I would just pick up on what Ashley mentioned, that you don't have to get an approved JD. You can just assume jurisdiction on site and move forward with a preliminary JD, or what they call no JD at all. In that case, you're assuming jurisdiction of the resources, accepting the permit requirements, and just moving forward. If you go with the AGD route, that could lead to a lot of uncertainty that causes project delays and timeline issues for your project. So that's one way to tackle it, depending on your specific project.
Okay, thanks. Anybody else want to add to that? Okay, then we'll move on. As promised, here is a list of all our contact information, our email addresses, and I'll leave this up for just a minute if you want to jot anybody's address down so you can contact us afterwards. And then we will begin looking at some audience or some questions that you have submitted. And I'll take the slides down in just a minute so that we can see the panelists a little more fully. Here's a question about permafrost wetlands on Alaska's North Slope. How do those fit into the revised waters of the U.S. categories? Does anybody have any thoughts?
I don't know that we have anyone from Alaska region on the call here. Has anyone worked in Alaska?
No, I haven't, and that is actually an excellent question. I saw that come up, and unfortunately I don't have an answer for that one.
I would note, overall, and I don't know how this applies to permafrost, but remember the Clean Water Act, we're looking at surface water features. So that could be part of the discussion there.
Yeah, and I think it's still going to fall back on the two tests, regarding those wetlands and their juxtaposition on the landscape and connection to other waters.
So relatively, the significant nexus test would probably,
probably be more applicable.
Probably more applicable, but you got to look at it in the context of all the other permafrost wetlands, and that can get to be a very large review area, and cumulatively they may be able to establish a nexus. But unfortunately I haven't had a lot of experience in this in Alaska. My experience in Alaska is only in fisheries, which doesn't really apply here.
I would add one thing we haven't talked about today is assessing wetlands, right? So the Corps' wetland assessment includes looking at all three parameters: hydrosoils, hydrophytic vegetation dominance, and hydrology. So even if you have some sort of potential aquatic feature, it may or may not be a wetland.
That part of the wetland regulation has been constant throughout the decades. It's just how we define a wetland is constant, but then whether or not it's jurisdictional has been up for debate. Okay, here's a question about ag drainage tile. Does an ag drainage tile count as a relatively permanent water body? Would a ag drainage tile satisfy the test for adjacency for a wetland? I assume they're talking about subsurface drainage tile.
Subsurface drainage, yeah. And the tile itself and maybe the drainage itself most likely would not be considered relatively permanent water, but you're going to have to look at it from the significant nexus standard. What is that tile draining, for one? Because those inputs, if you have an ag drainage tile and it's necessary, are you dealing with a prior converted cropland that has wetland characteristics or doesn't? and this may kind of relate to another question I saw on the Q&A list, that just because you have a prior converted cropland does not mean that you're necessarily going to have a wetland, right? So it just depends on the time of the delineation. And of course, here in the Mid-South, that could vary year to year because they rotate crops annually for nutrient management. So in the same field that delineated out as a technical wetland because it was an irrigated rice field, the following year it's going to be a soybean field, and it won't meet the vegetation criteria to meet as a technical wetland. So that kind of muddies the water, and of course it just diverts us back to case by case scenario. But all that stuff to be taken into consideration as to where this ag drainage tile is connected and what it's draining.
Thanks, Heath. Does that I think you were alluding to the question about rice fields and how would rice fields be considered under this new rule?
Right. A rice field, it technically meets as a wetland in most cases because it's routinely irrigated and inundated. So it tends to go into anaerobic conditions and have hydric soils, and rice itself is considered an obligate wetland plant. So then it goes back to, is it solely artificially irrigated for the source of hydrology? Because we know the planted rice is artificial, right? The vegetation itself is documented as artificial. But if the site does have some natural significant nexus with a natural source of hydrology other than irrigation, that's when you get into, okay, now what is its condition today? What will it be after it ceases being in ag production? And it gets into the whole chronology of conversion of use as well. So it depends on how fast that's going to happen and whether it reverts between the time it's in agricultural production and the time it's developed and there's a change of use. So a lot of that is going to be, like I said, on a case-by-case scenario, and the timing of development and timing of permitting through the Corps of Engineers. So that kind of goes back to the JD longevity question, right? If you apply for an approved jurisdictional determination and it comes out as non-jurisdictional, you basically got 5 years, you bought 5 years regardless. And so it just comes down to an operation and maintenance issue at that time. So you may not have had to get a permit for development at the time because it didn't meet, but if it still has that natural hydrologic connection and hydric soils, it could still revert to wetlands, and then you run into an operation and maintenance issue down the line. So that's one of those cases where, as a consultant, I would try to advise clients not to develop in that situation if they can avoid it, because it could run into future problems.
Okay. Thank you, Heath. Bonnie?
I said contact Heath.
Yeah, thank you. Where do flood detention facilities fall into the rules? If they're facilities that only retain water during storm runoff events, are those waters of the U.S.?
I believe those would be exempt.
So if I don't know what you mean by a flood detention facility, if you're referring to like a reservoir or something like that, we would be looking at whether that's tributary to relatively permanent water and A1 water, or meets one of the tests. We might also need to apply the impoundment question, whether it was created out of a water of the U.S.
Yeah, it's really going to depend on the situation, because a lot of stormwater detention basins are not that they have non-point source runoff basically that feeds them, and they're not necessarily impoundments, but they could still have wetland characteristics within them. So I have seen that in some cases where they're abandoned but constructed stormwater detention systems that basically have naturalized and were considered jurisdictional, and then in other cases where they're maintained and continued as use, kind of like what were the exemptions for wastewater treatment facilities and lagoons. If it's continually maintained as a detention basin, it's usually exempted.
That relates to another question. Somebody asked about what is the elapsed time frame for an abandonment of an exempt feature, such as a wastewater treatment pond or a water-filled depression. So that kind of relates to what you were saying, Heath. A stormwater pond that was abandoned and took on wetland characteristics. Is there any guidance or any rule about how long does it have to be abandoned before it would be considered a water of the US rather than a stormwater pond or a treatment pond?
We're really getting into the weeds on that one.
Yeah.
A lot of questions and components to that scenario that we would need to detail out.
Okay. Okay, here we have a question about swales. A swale by definition does not include an ordinary high water mark. Please clarify when a swale is included or excluded as a water of the US.
Well, I think that question was asked and answered, because that's exactly the case. If you have an upland drainage swale that does not exhibit an ordinary high water mark, it is indeed a swale which is exempted. It's when that, but in that same water feature, you could have basically a reach change. So the upper reach is a swale, and there may be some point where there's an erosional feature starts and starts carving out an ordinary high water mark. So then you have to draw the line within the same stream or swale or watercourse feature. Where is it a swale? Where is it an ephemeral stream? And so there's no blanket application there in that situation. But if it's a swale from start to finish, then it's exempted.
We might
Okay.
look to the slide I presented on relatively permanent water and the continuous surface connection. So, I presented when you have a continuous surface connection, you might have a physical feature between your subject feature and your regulated water, such as a swale or a pipe or a culvert. It does not mean that feature itself is necessarily jurisdictional. It means that it does not sever the jurisdiction between the two features. So think about that when you're looking at continuous surface connection. It doesn't mean all the features in between are jurisdictional. We're just looking for connectivity.
Okay, thanks. We're running out of time, but I want to throw one quick question to Ashley. Do you think federal courts will issue an injunction to stop the implementation of the new rule?
That's the $1 million question. If I put money on it, probably at least one federal court will. I think we're going to see, we have litigation going on in Texas already. We'll have litigation filed elsewhere. I think chances are we'll probably see some form of injunction. But whether we ultimately see the rule overturned or remanded is a separate question. I think I think the Biden administration has done some homework in how it finalized this rule in anticipation of a challenge, in anticipation of SACIT, and made some decisions based on that. I also think that the SACIT case, because they followed up with the court specifically raising their new rule, we may see some discussion of the new rule from the court that informs that litigation. So it'll all be interesting to see, but I would not be surprised if we see some form of injunction and end up in a checkerboarded situation potentially again.
Okay, great. Thank you. Well, thank you to the panelists, and thank you to all who attended today. Appreciate your time and your attention to this complex and ever-changing topic. And you can reach out to us if we can help you with. You have any questions that you want to discuss this further. Thank you, everybody.